presentation on due process hearing outcomes by Nate.
And just an FYI, this is one of your responsibilities. If you remember from the presentation we had last month or from previous presentations, in the code of regulations about what a state advisory panel does, one of the things that you do is review due process hearing findings, and so we do that annually. You want me to put it for? Yeah. So hi.
That's
Yes.
a quick question.
Yeah.
Just so you know our duties on how that applies to what you're going to say. Are we responsible for reviewing globally trends? Or are we responsible for reviewing every finding? How's that
Global and trends, because then you would consider the findings in due process hearings for as you're considering recommendations to make the State Board of Education. That information could inform your recommendations.
Sorry to interrupt.
Good clarification. Thanks. You're fine.
Yeah, and so I'm Nate Dearden. I'm at the State Board, and my title is Student and Family Rights Coordinator. So I work with dispute resolution, family engagement, youth in custody, equity, 504, civil rights stuff. So a lot of things that pertain to families. And in my 4 years here, this is the first time I've had to do this in the context of due process hearings because we haven't had any for a little while. I've come to you before and talked about some state complaint decisions because we still wanted you to have a sense of what was going on in dispute resolution. But this year we actually had 3 due process hearings this summer and late fall, and so or early fall, and so I'm here to share a little bit about those 3 cases with you. So I've tried to summarize things. That said, 2 of the 3 decisions are posted online, and so you can read them in a redacted fashion, and I can tell you where to find those afterwards. And the 3rd one should be up in a week or 2. I just had to redact it and make sure we have a little bit more sensitive issues than the other 2 did. But you could read the whole thing, and what I've tried to do is pull out some key points. But I wanted to remind you as we delve into these cases that under the IDEA, whoever files the due process hearing request is the one who has the burden of proof or has to prove their claims, if that makes sense. And so as we go into each case, it is an important distinction to see who filed and to see that, you know, whoever filed, it's the evidence you present that you have to persuade the hearing officer by preponderance of the evidence that your allegations are correct and whatnot. So that's kind of the context we're looking at. So the first hearing we had, I think, involved Logan School District. Next slide. Sorry, so I was going to think, I think it happened this summer. It happened in May. Oh, good. That would be good. So with this case, the parent and the school had many meetings leading up to the parent's decision to file. They had engaged one of our facilitators a couple of times prior to filing. I like to give you a little bit of the background that led up to the hearing, and that's kind of what we call in law the procedural history or the procedural background. So you can see in February, parent filed a due process complaint. Something about due process is there's a 2-year statute of limitations, and so what you can include as a parent or as a school in what you're filing, it can only go back 2 years. And the attorney in this case was trying to make an argument that evidence and claims should be brought in past those 2 years. Now, absent getting into a bunch of sticky case law with you, what I'll tell you is nationwide this is pretty set, but there are some cases, for example, in Pennsylvania and a couple East Coast spots where they're going a little beyond the 2 years. And they pulled in years of claims, and different people have different thoughts about whether that's consistent with the IDEA's intent or not. And so this attorney was kind of trying to pull in some of that, but ultimately the hearing officer said we're going to stick to what occurred in the past 2 years, and that's what we're going to review. They extended the timeline several times for different procedural reasons, and that's why you see kind of a longer length of time than some hearings take place from February to May. So the hearing took place from May 20th to May 23rd, so it was 3 days long. And then afterwards, the way it works is each party gets a transcript of the hearing, and they file post-hearing briefs with the hearing officer. So there were some extensions due to that piece, getting the transcripts to the parties, getting that to the hearing officer. So the hearing officer then issued the decision. So the final decision was issued on June 17th, so this summer. So we're looking at a couple of issues in this case. And I'm sorry if I put too much text. It's legal, so I want you to be able to pull things and look at things later, but I can kind of summarize for you what you were looking at. One of the parents' concerns had to do with IEP services, and she was alleging that the school district kind of provided just a very generalized IEP to her student. She was alleging that evaluations weren't appropriate, and that didn't drive a specific type of IEP that provided individualized services to the student. Connected to that, parent had concerns about the assistive technology that was available to students at the school, and alleged that the type that had been provided by the school was not appropriate to provide FAPE. Lastly, and you see this in a lot of dispute resolution things, so it probably doesn't surprise you, parent was arguing the school district violated her procedural safeguards, and she had some examples to share around that, including feeling that the school didn't consider outside information, they didn't allow her to participate in the IEP development. There was a meeting that went fairly long in the spring where she felt that because they didn't take a break, that had violated her rights, like a bathroom break in the middle of the meeting. And finally, there was some tricky stuff with a potential witness that she was alleging, and it gets a little tricky, but those were things that she put forth. So this involved a high school kind of transition age student, and student had some significant disabilities. As you can see, student has an IQ of 40. Communication is very limited. A lot of limitations that the student has. And the student had been in the school district for years, but during the 2018-2019 school year, the student attended irregularly, and by the time that parent had filed this, she had unenrolled student, and student was receiving services through Utah Behavior Services in the student's home. And so that's a little bit of background about the student in the case. So this is kind of a slide to frame the different cases too, and I know you're familiar with this, but this is language that kind of comes from the IDA and comes from Andrew. What is that FAPE standard that hearing officers are examining as they're making their decisions? And so we're looking for an IEP that's reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances. We're looking for that calculation to confer some educational benefit. And so in this case, in light of the student's circumstances, was a big consideration because the student has a lot of needs and also some significant limitations. So in terms of that first issue, whether or not that IEP was just a general IEP or whether it was designed to meet the needs of the student, the hearing officer's conclusion was that the parent didn't offer evidence that showed that recent reevaluations were not adequate, and the school district put forth various experts and educational professionals who testified that student had made progress in light of student circumstances, and they relied on evaluations, prior IEPs, and student data in making that decision. You all probably know, many of you have participated in a lot of IEP meetings. We reevaluate every 3 years at least. And as we get some of our students getting older, it is common that certain evaluations aren't done over and over because the team may say we have sufficient information. And that was one of the things that played in this case, is they had not done some evaluations in years because they felt that certain information they had was already appropriate and gave them a sense of what the student needed. And parent had been a part of those conversations and had not disputed up until this point. So that was something the hearing officer drew upon by saying, up until now, you did not dispute the fact that evaluations haven't been done in the past. The team developed something that seemed appropriate, but when this came to the hearing officer, the team recently had done some reevaluations at the decision of the team, and so that helped guide some of the decision as well. Next slide. So I think I just reiterated that what you see. So yeah, the hearing officer just said there was no evidence to show that the evaluations weren't adequate. So there's deeper analysis in the decision, but the hearing officer then looks at how that informed the development of the IEP and felt that the IEP was appropriate, the student was making progress. So our second issue had to do with that assistive technology issue. And you all know that's a requirement that teams need to consider and provide if students need that. And there was some disagreement about a Dynabox versus an iPad with Dynabox application on it. And I am not an expert in AT, so if any of you are, I put up a little more details. But essentially, at one point, parent pushed and wanted just the Dynabox to be the device instead of the iPad, and the team made that change. The hearing officer looked at that and said either device was appropriate. They had an expert who basically testified that the only difference between the two devices was durability, that the Dynabox was water resistant and more durable. So in terms of what the student was accessing and using to communicate, the evidence presented, the hearing officer felt that both of those things were appropriate, so the team had appropriately provided and decided on different assistive technology devices.
Sorry, my mouse has died, and it's giving me the patching.
Oh no.
Yes. Oh, no. You can't see it, but it's about to shut itself down. So
Your computer is.
yeah, so keep going. Don't freak out. Just blows up.
Okay, well, I need my notes if I'm gonna let me pull up my computer and we can bring this back. Okay. The third issue I know dealt with the parent engagement piece. And so, okay. You can go to the next. Yeah, you can go next because I just talked about that.
There we go. Okay.
Okay, so this is another piece that applies, this paragraph mainly. When hearing officers review hearing matters, they're looking for two types of violations. They're looking for procedural violations, meaning those procedural safeguards or procedures like timelines and things that schools need to follow. And then they're looking for substantive violations, which is like the substance of what was provided to the student or what occurred. And so most of the time, procedural violations will not lead to a substantive violation unless there are certain things at play. And so one of those things is that a school's procedural and substantive is they need to involve families. They need to involve parents and not student notice requirements. You guys know there's timelines and things like that. But if a procedural violation happened and the hearing officer felt that it did not impede the parent's ability to participate in the process, they may say there was a procedural violation, but it didn't translate into a denial of faith because the evidence shows that the parent still was able to participate. And so that was one of the pieces that they looked at with this case, is that we're looking at whether some of these violations parent was alleging caused the deprivation of educational benefit, or made it difficult for parents to participate in the decision-making process in these meetings. So, reviewing what went down, and you can read the decision. The hearing officer felt that parent had the opportunity to fully participate in the process. So one example is that meeting that went really long. And at one point, parent and her attorney wanted to pause the meeting, and the team decided to move forward. I'm not saying that's a best practice, but as the hearing officer reviewed things, she found that a lot of evidence that parent had always offered evaluations, data, participated in conversations, made requests, and so the hearing officer said, looking at some of those things like that, I do not feel that parents' procedural safeguards were violated in that way, or that she wasn't able to participate in the decision-making process. So that's kind of where the conclusion was. So in that case, if you're from layman's terms, the school district prevailed in that case. Parent did not prevail because the claims parent brought forth. Parent failed to satisfy that burden to establish a claim of a denial of faith. So, quick pause for questions or comments. Yeah.
How are the hearing officers chosen? Who are they?
So we have a roster of hearing officers, and we use contracted folks because we're not a state that has enough hearings, so we have full-time employees. So our hearing officers have law degrees, they have experience presiding over administrative hearings in Utah or other states. This hearing officer in particular is from Alabama. And so we work with a roster of folks, and we rotate through those folks. So depending on when things are filed, we go down our line. Those folks have an active bar license, and they're actively trained year to year on best practices and what's going on in the law. A lot of them run a private practice, and this one works as a mediator for us as well.
What's an example of a substantive violation?
Good. So some examples of substantive violations, a lot of those, what you can see is maybe implementation issues. So we wrote an IEP that was procedurally great. I could look at your student and look at her needs and then frame that to a great IEP. But then we find out that related services weren't being provided consistently, or student wasn't in the placement that matched what was on student's IEP. And so it's really getting into that substance of what the district or charter should be providing. I think we'll probably touch on some substance in the next two cases, so we'll get a few more examples that way.
Yeah, my comment might be premature before we get the other ones, but when I hear these, and just based on my past experience, the thing that always comes to my mind, and how we can make recommendations to improve basically customer service, because this whole thing, what I hear, and I sort of experienced it myself with one of my kiddos, a school or school district that just shuts a parent down, and we get to this point, there's really, look at these things that really, when you see them on paper, you're like, this should have been able to be worked out, and this makes me sad because these are the kids that get hurt, and the family's time and energy for all this drama, that had someone just really listened, perhaps, what a difference could have been made.
And that's great perspective on a lot of our dispute resolution cases. What I'll say in this case is there was a long history. The school had met with parent about 6 times in IEP meetings that sometimes went 4 to 6 hours long before we got to this point, which I think shows some communication breakdown. But it is, at least this year with some of the cases I saw, I will tell you from my perspective, I felt that the school district or charter made a lot of effort to work with the families who filed. But there's different sides to every story. And I do agree that, as you'll see the next case, I think, or one of the other ones, there was a facilitated IEP. So some of these folks tried to be using some early dispute resolution and just were not able to come to terms. In this case, the attorney was asking for a lot, including money to go to a special needs trust fund, years back of compensatory services, lots of big asks, and that made it hard for the school district to come to agreement in resolution or mediation type situation. And this attorney came from out of state and has kind of a different perspective in terms of just special ed dispute resolution here. And so we're seeing some tension out in the field right now because he's pushing the boundaries or wanting some things that you can read about in the decision that some schools are saying we can't like justify that, or the facts of this case don't justify that. So that's something to keep in mind. Up until recently, there haven't been a lot of attorneys out there offering the services to parents. And that's coming from practicing in DC where dispute resolution is crazy and all the time. My perspective here is that maybe some reason why we have some lower numbers is parents call me or call others and don't always find folks to represent them. And as you know, with all litigation, sometimes there's strong cases or sometimes there's some cases that don't always match up with what folks are asking for versus the facts. But great point about communication and just working together. Any other questions about this one? Yes.
Clearly, with a lawyer that has his own agenda or her own agenda in the situation, may not have their client's best interest at heart, and the overall thing they're trying to change the law. This is a representative capacity. Or can you make sure that actually authorized and approved practice law in Utah before you go forward with the process?
Well, the hearing officers do. So as soon as some parents will file themselves and they get an attorney, others their attorney will file for them. And I think this attorney filed in this case, I could be wrong, but if you file alone as a parent and say in the school district, your attorney files what's called a notice of appearance in front of the hearing officer. And so the hearing officer checks that that person is authorized to practice law. And that is a distinction here because in Utah, we don't allow advocates to represent parents in a due process hearing. And so parents can have somebody come and sit with them, but that person can't help them present evidence or question witnesses and things like that. So that is something the hearing officer reviews at the very beginning of the case.
But parents can represent themselves.
They can. And that's what the next case they had, was a parent who represented herself. Any other questions about this one? Okay. And I'm close to time, so I'm sorry. I'm trying to go fast, but you guys help me stay on the agenda because I can summarize things quickly. So this case was involving Ogden School District, and similarly, this was a case where parent and school district had a lot of meetings and had a facilitated IEP prior to the school district filing. So if you look at the IDEA, the times when a school district will file due process against the family are fairly limited. Most of the time it's the family filing because they're alleging you didn't follow the IDEA. But one of those instances has to do with independent education evaluations. And you want to skip forward one slide? So I included a little bit of language to help you understand that if you're less familiar. But basically the law says if the school does an evaluation that you as a parent disagree with, you're entitled to go and get an independent evaluation and at no cost. And so the way that typically works is the school should have some policies and procedures to help you access that. Sometimes they'll either reimburse or they'll directly pay that person. There's some qualifications connected to what the outside evaluator has to have in order to do something that would qualify as an independent evaluation. So the law allows parents to ask for that if they disagree with an evaluation. That said, the IDEA also says school district and charter, if you feel that the evaluation you conducted was appropriate and feel like it's full semester, then you can go to due process hearing and present in front of the hearing officer saying our evaluation was sufficient and so we are declining to provide an independent evaluation. This is one of the instances in the law where the school district only has two choices. You either do the IEE and help did that, or you file due process and go to a hearing to show that your evaluations were sufficient. So that was what was going on in this case. If you want to go perfect. So parent represented herself in this case, and just a little bit of procedural background. They did engage in mediation. They were not successful. Right before the hearing, the night before, parent objected to the location of where the hearing was to be held that the parties had agreed upon about 2 or 3 weeks earlier through different communications. And so the hearing officer declined to change the location at the last minute because that was pretty tricky logistically, but he said we can do electronic participation, we can do phone participation. So when the day of the hearing came, the next morning, the parent did not show up. So they held a hearing, the school district presented its case, they had witnesses and things like that. That evening, the hearing officer reached out to parent again and said, we're open tomorrow, we'll hold the hearing again tomorrow, and you can come and share your case, and parent did not show up. So it was kind of, if you look at the hearing, it was kind of one-sided other than what the parent had filed because we didn't have that other side presented in the hearing. So the two things that we've got procedure, we've got substance. So the hearing officer was looking at, parent was alleging the school district took too long to tell me what they were going to do about the IEP. I asked for several. They took a while, so that was a procedural violation. Also, parents said I brought in these outside evaluations to the IEP team and they did not consider them. And that is a requirement under IDEA that you need to consider. You don't have to follow all outside evaluations as IEP team, but you need to consider. And so that transfers into some substance issues where a parent was really concerned about the areas of occupational therapy and academics more generally. And so she was connecting this to substance, saying because you didn't do a sufficient evaluation of my child in these areas, the services and supports you're providing are not appropriate. So when the hearing officer looked at the parents' procedural concerns, he saw a long history, and I was copying on a lot of these, not because I asked, but because the parent chose to do that. There was a series of communications and meetings where the district attempted to clarify parents' requests. Part of the challenge is that the parent was asking for things in a lot of different areas and subjects, and so some of the communication back and forth with school district trying to clarify, like, what exactly are you asking for? And it's again some of that communication breakdown, as well as a parent who was representing herself. And so I know she worked with a parent advocate through some of this, but if you do look at the decision, there was a span of months. It went, parent initially kind of requested things, I think, November over email. They had meetings through December, and some of the evaluations weren't, or district didn't file, I think, until March. And so I think it's reasonable for parent to say that took a while, but when the hearing officer looked, he felt like the communications and what was going back and forth documented the district's intent to kind of understand what was going on here. Also, by looking at evidence, the hearing officer felt that the school district had considered both its own evaluations and evaluations from outside the parent. One of the things parent presented in one of the meetings was a list of like 40 accommodations or 40 things she wanted added to the IEP. So you can imagine that like things took hours to go through for the school district to consider. And the hearing officer found that many of those considerations were implemented and listened to. And students, as a side note, was making progress, and so that balances parents' concerns and seeing students doing okay. We have evidence to show progress and things moving. Next slide. So the tricky thing is, and this gets a little legally, so I'm going to try to summarize it for you, is the Department of Ed issues Dear Colleague letters. And those Dear Colleague letters, people can write to the Department of Ed and say, I have a question about this regulation, like how is it implemented? Or, You can ask questions that you don't feel like the regulations really answer with different nuanced things. And over the past couple of years, the Department of Ed has issued multiple letters in regards to this IEE issue. And two of those letters are something that the hearing officer looked at. One of the letters, or maybe both instances, dealt with a situation where a school district didn't even evaluate in a certain area. And so a parent wrote the Department of Ed and said, what if my disagreement is that they didn't even look at speech, or they didn't even look at behavior? So there's nothing for me to disagree with because they didn't even do it, but shouldn't I be entitled to that? And so the Department of Ed said, because I think the school district in one of these letters had said, you have to wait now for us to do ours, and we can disagree, then we'll do yours. And the Department of Ed said, we don't feel like that's the intent of the IDA. We can interpret the disagreement piece as you just disagree that they didn't do a comprehensive evaluation. And so now they need to get on the IDE for you in this area, even though there's not a specific one for you to disagree with. So that's kind of at play here, because one of the areas, academics, was an area the district hadn't been able to formally assess. And some of that had to do with what parent wanted, like an outside person to come in and assess the student in class, and that's not really what the academic evaluations in the IDA go toward. And I'm getting ahead of myself, but parent wouldn't even give district she wouldn't grant them consent or give permission for them to test in that area. So as the hearing officer is kind of looking at this, he's saying, first of all, the district didn't even get to evaluate in the area of academics. And he's trying to balance this guidance from the Department of Ed without it going too far. And so in his decision, he made the point, if we go off of things the district hasn't even evaluated yet, we could get really expansive, and the parent could ask for an IEP and a bunch of different things. And so he's trying to balance that idea that most of the time it needs to be something you specifically disagree with, or you need to show that a certain area was not covered. In this case, it's tricky because parent didn't even present a case. And so what the district presented, the hearing officer considers and felt like they struck that balance in the right way, given the fact that parent wouldn't allow them to consent to do an evaluation in that area. They had used all the information they had for academics, otherwise like informal data, already existing data, to make their decisions. So you can skip through this because I just kind of talked about that. So also, as I said before, why a school district would file would be to show that their evaluation was sufficient. So they did that with the occupational therapy evaluation. They put experts on the stand to show that what they had done was appropriate and allowed them to provide services aligned with the students' needs. And then I think I've already discussed the academics piece. So any questions about that one? Yeah.
Are there ever case law or association? They initially an evaluation was done. Parent denies them the ability to assess the district to assess, but later on grants it throughout this due process, or would that be done more in mediation? Like,
Good
you
question.
see districts kind of covering their bases as the process is started? They continue.
Yeah, so good question. So as you guys have probably heard the term stay put. So when a due process hearing goes into play, there are some things that stay, and that parents can invoke stay put, meaning I want my student to stay in the placement they're in while we dispute that. But otherwise, yeah, this process is kind of looking backward, because whatever you allege when you file that, that's what the hearing officer can look at. To your point, the parties continue to work together. The LA still has to be providing faith. So that doesn't stop timelines, that doesn't stop their requirements to do certain things. And sometimes things are worked out in mediation because of conversations like that. And so then it will get withdrawn. But for example, we had a case a couple of years ago where a parent was asking for a lot of compensatory services, was making some pretty big allegations. Student was overdue for triennial reevaluation, and parent would not give school district permission to reevaluate. And at one point, the hearing officer ordered parents to give permission because the hearing officer said, I cannot make decisions about compensatory services and all these things you're asking for when you file in front of me if we don't have current evidence, because evidence was 3 or 4 years old and the student had a lot of significant mental health and other issues that the hearing officer felt were very relevant to her making a decision. And in that case, parent ultimately withdrew her request because she didn't want to have student evaluated. Yeah.
Just a quick question. So this one was just about the evaluation, not the actual services being received.
Yes.
But it was about the evaluation.
Yeah. And that's what you'll see with the school district filing, because again, they're never going to file about that. They have the duty to provide the services. Parent did have concerns about some of the services, but the way that the filing goes, you can't add on to your opposing party's filing. So what parent could have done was counterfile and file another request to have a related hearing on this, and parent chose not to do that.
I often hear parents voice concern when evaluations are done and a low reference test evaluation is not able to be completed, and then the service provider makes a statement saying, as a student, we weren't able to do this, this is our observation. Parents are still concerned that that's subjective. So how can parents reach a balance and know that the intent was made to do the evaluation, but nothing was received? So how can we help parents understand that better?
Yeah, I mean, for me, I want them to understand this, right? That they can ask for an outside evaluation, so they can even ask for an outside observation type thing. I'm an attorney by background, so also when I have parents call me, I love that our staff has a team with expertise in a lot of different areas. And so I explain to parents, I can't give you legal advice, but there are often a lot of different types of evaluations, and sometimes educators or staff may not be as familiar with certain types because of certain students who have unique needs that they haven't dealt with before. So if I speak to a parent, or if you do, I say, let me connect you with my colleague Tanya. She specializes in autism. Let me connect you with my colleague Kim Fratto. She has a strong background in specific learning disability. Those are two that I get calls a lot about. Lavinia Grippentraub in terms of transitioning and some of those types of assessments. So I always try to connect them to somebody on our staff who has more expertise, and often that involves them then following up with the school to say, hey, have you looked at these types of things? Parents communicating this, would you be open to doing this or that? And so we're happy to do that. I know there's other folks even in this room who probably have some great expertise in some other ways you could assess students' needs, because I think some of the cases I see that is a piece of it. That it was a unique challenge or unique needs and the team didn't quite know. And so with our state complaints, what you'll see is this fall I did a lot of training on what does the IDA require for you to do a comprehensive evaluation, because as you know, that's the foundation of the IEP. And sometimes we don't have great IEP, it's because we didn't fully examine what the students' needs were. Yeah.
How much training is done with schools on when an outside evaluation does come to them? Because that's just one of our challenges, is that, I mean, obviously residential and day treatment facilities do extensive evaluations with psychiatry teams and psychologists. And I find that they get them and then they go, well, we have to do like 6 weeks of our own evaluation. And it's frustrating because a lot of these kids are in treatment for a long period of time. Teams have observed them, teams have tested them. And it's just surprising to me that the school who has a psychologist, not a team of psychologists, it just seems very disregarded. And so I don't know how to communicate that to parents and saying, except for, yes, I realize that you had 4 psychologists and a psychiatrist, but their school psychologist
feels like this is still necessary. Like, I don't know how, like, we go without that. We as our residents need a psychologist. I'm not just in physical psychologist. I'm just saying.
Different schools have different approaches, and I've seen a range. I've seen some schools, and I think in Utah we're very conscious of not over-testing our students generally. I think that's a culture we have here. And so I see many parents coming out of a situation like that saying, do you really need to do that? And I have seen some schools say they've had their psychologist review it and they feel like this is appropriate, this is helpful, we can use this. So they may say, we're missing this one piece, we're going to look into this thing or get this information. Flip side, I see some folks very tied into, I have to do this. And we can't, what I tell schools is to be reasonable. And if you have the evidence you need, there's no need to go get more. That said, some schools make the point that when kids are in a highly restricted environment that's very regulated, there may be some things that you see in that environment that look different in this environment. So what I want teams to do, though, is to not delay timelines or not delay providing appropriate services because of some things like that. They're required to consider, they're not required to implement and follow everything, but I do work with a lot of administrators who are reasonable and they're not interested in piling more evaluations that are unnecessary on kids. But that said, families are welcome to utilize dispute resolution to bring some things about. And I don't always want to drive us toward that, but sometimes that's the only way that I can get it in training where I have the authority to say, you did this wrong.
Well, just to throw it out there, my understanding, and I have a friend that went through this, part of that disconnect is the treatment facilities, it's a completely different environment than these school settings.
Yeah, that's kind of what I was trying to communicate. But yeah, it's a different environment.
Yeah, so the school where they want to honor what's coming from the day treatment, it's such a significantly different environment, concentrated resources and stuff, that significant disconnect happens because that school environment is so different and figuring out how to collaborate to get safe over. So I don't know.
It's really case specific, as you guys probably reasonably. Yeah.
Well, I have to make 2 points. One of them is that point that the evaluation in one context may use different recommendations or wording, which doesn't translate into how we put this in practice for an IEP. Whereas the school psychologists may design things in that ultimate, how do you get recommendations from this? But the other point, not contrary to you in any way, but you can find an expert to get the opinion you want. So you have to take some of these things with a grain of salt just a little bit.
That's true too, and some of the tension that I see in cases like this, and I think we're in this case, is that parent doesn't then give school permission to communicate with the expert who did some outside work. And sometimes schools can work with what is given. Other times they say it would be very helpful to communicate with the evaluator so I can understand a little bit more context. And I see both sides because I think some parents, especially with mental health or other things, they really want to protect their family and their students' privacy, and that's their right. From a school perspective, sometimes it does make it difficult to interpret things or understand things, in part sometimes because they have concerns about the evaluation that was done. And so they're like, it would be helpful to talk to this person. If you won't give me permission, then we've just got to go with what we have. Yeah.
Is that something that there's any guidelines for, like from the Board of Education? Because the must consider it is so broad. Like all 3 of my kids, like they have extensive neuropsychs, from very reputable places, and they even come with like 40-some page neuropsychs with like 2 pages of educational recommendations and things like that.
Yeah.
And I have never had any school district accept any of those. Like they're like, we're doing our own thing, like right on there, and I'm like, so I'm right on this, but there's like so much time and effort that goes into that. And yet, are there any guidelines like if it's, these reputable people, it contains educational information, or because it does to just go through it all again with the kids is so frustrating.
I mean, a lot of guidance is in case law. The guidance comes from the Department of Ed. What's our ruler? Well, we're trying to create an IEP that provides faith. And from a school district perspective, and what I would say as an attorney to them is if what parent is presenting is rational and grounded, like that's what's going to be used against you in a due process hearing if you went to hearing. So you need to consider that as somebody like, if you feel that it's reputable and if you feel that it would help you to provide faith to that student, you should incorporate some of those things. And I do see that happen a lot. That said, what I'd say this draws in as well as written prior notice. And I wouldn't say presenting a school district with an outside evaluation triggers them necessarily to do that, but in meeting conversations if the parent is actively advocating, I want these 3 things that were recommendations. So it's grounded in data about my kid. I'd love to have these incorporated. And if the team experiences disagreement, I am training LEAs to give written prior notice as to why they are refusing to act on that request, because that is a valid request from parent as a member of the team. And written prior notice then going to you as a parent allows you notice of what they relied on to make that decision, which can help you then dispute it. And that's kind of that tension or balance in the law where the law says ultimately LEA can say, this is our decision of faith, and parent can say, well, I'm taking your decision and kind of your rationale and I'm challenging that in a dispute resolution procedure because I would disagree.
On that note, do you guys have a sample that you can put on your website or anything?
We have a form, and the tricky thing is written prior notice comes into play whenever you are proposing or refusing something. So it comes into play every IEP. So there will be some
that question that came up that I was trying to do.
Yeah, so a lot of educators may look at you like deer in the headlights, unfortunately, but it's in there. What I'm telling them is you're doing it often because it's embedded in the questions and the forms that you fill out. But that said, through a lot of our state complaints over the last year, this is a frequently occurring violation. And so our compliance team and I and some stakeholders and the LEAs have worked together to make sure our model forms are more comprehensive because we felt that some of them were missing some required elements. But typically it should be embedded in like the change of placement form or the consent for evaluations. They're saying, we're giving you notice, we're going to evaluate what you give and stuff like that. Most districts also have a standalone form because sometimes your request comes kind of outside of all those things I just talked about. And so they would issue either an independent, yes, we're going to move forward, no, we're going to do this instead. Sorry, hand and then hand.
This is actually for me. So I believe last year in our mental health, we did ask for a spelled out more transition between that conversion between sort of the hospitalization stage and look at that. Do we know if there's been any sort of movement on that?
So we actually have been working on that, and Nite actually leads the team that has been considering that for students that are in custody and foster care, those kind of things. We also are bringing a specialist on. We just offered the position 2 days ago, actually, to an individual who will be working with some residential treatment centers. So, yes, we are working on it. Finding somebody to take the position that we've been looking at. We've been working on that since July 1. And long and a little frustrating. But yes, thank you for bringing that up to make it explicit to everyone.
I'm well over time. Do you want me to, what do you want me to do? I can quickly summarize this last one. Travis?
Yeah,
Travis is here at the beginning. That's why I'm trying to be careful because I'm eating his time.
Those two, it's your agenda.
I think if you can summarize the points quickly. Okay. So our third case dealt with Mountain West Montessori Academy. This is a charter school. It involved a student in elementary school, and it was a little more kind of typical denial of faith type stuff. The procedural history was a little tricky. Parent had an attorney. And they had some delays with some different timelines. So some were things I described in the first hearing. And really tragically and unfortunately, one of the parents passed away a week before the hearing was initially supposed to take place. And so there was some time off where folks were deciding if they still want to go forward with the hearing. And so that is why this hearing didn't really happen until September, which is actually this school year. It had been filed in the prior school year, so if you are reporting to OSEP, that's why we're covering it now instead of a year from now. Attorney and school engaged in some resolution type discussions and were unable to come to agreement. This was the same attorney that represented the family in the first case, and so again, there were some big asks that the school felt they didn't really want to grant, and so continuing disagreement led to the hearing taking place in September. So some of it was around child find. There was, as you guys probably have dealt with different kids and eligibility situations, this was a student who has ADHD. Not all of our kids with ADHD need an IEP or qualify for one. And so at first I think there were some minimal challenges and parent expressed a little concern, but what the school did was they implemented RTI. And they saw the student making some success in that way.
Can you share a copy of the presentation with the group after that?
Most likely,
I've got
yes.
them. He's already sent it.
Yeah. So I also did a presentation on this to staff at the USBE last Monday. We're looking on ways of how to get that video distributed so that basically anyone can see it and send in questions. So, any other initial questions before we get started? voting? I stalled as long as I could.
You did great. That was like a fantastic amount of stall.
Oh, dear.
All right.
Okay. Go ahead. So this statement here is very, very important that we want to always preface this conversation with. This is part of the board's strategic plan. Each student is taught by effective educators who are supported by effective school leaders. That is one of the board's key missions. And so that task, that challenge, that plan is an integral part of what and why we're doing. So that's a good thing to just bear in mind as we go through this. So the first thing we need to talk about is the current licensing system. And I've shown an image of an iceberg here because that's what the current licensing system is. Most people know about the standard licenses, level 1, level 2, level 3. Those are the normal licenses. Those are the licenses that very vast majority of teachers have. However, when you dig into the details, there are a whole lot more than that. Below the surface is way bigger in terms of what can be happening that people don't see, that parents particularly aren't aware of. Go ahead and go to the next slide, please. All of these, just so you're aware, all of these are either a type of license or a path to license that is not level 1, level 2, level 3. There's literally 13 up there, and there's more than that. That's not an exhaustive list. And as a parent, as the public looking at this is incomprehensible. It's the iceberg below the water. So that's one of the things that was happening. That's what the current system is doing. There are a lot of things happening that simply parents aren't aware of. They're sending their students to these schools. They assume the teacher's licensed. And it could be one of these. I don't know. So I'm going to give you a little bit of a timeline. This is not super important, but I wanted you to see where this has been, where it's going. And essentially, this process, this change started in August of 2016. In August of 2016, the board created the Academic Pathway to Teach, also referred to as the APT path to licensing. And there was a number of there were issues, there was some public feedback. It was in the newspapers if you were around then. There were some issues with it. And when the board sat down and looked at trying to fix, quote unquote, APT, because everybody has their own opinion, everybody has points of view. But ultimately they realized that the system that we had gotten so bloated and so complicated that it was unmanageable. And so what they determined was, rather than continuing to tinker, rather than fixing APT and trying to make all these weird pieces fit together, they decided, no, stop. We need to start over. So they created a task force. That task force met from August 2016 to September 2017. So for a full year, they gathered public feedback. They met with parents. They met with universities. They met with districts and charter schools. And we're trying to look at what a licensing system needs to be. Like, they were building it from the ground up. I mean, one of the first questions is does there need to be a license? They were literally building from the ground up. What is a licensing system? And so then in September 2017, the result of that work group was that they passed a motion in the board's meeting for staff to work with legislature to create a 3-tiered licensing system. If you're unaware of this, the entire level 1, level 2, level 3 license designations were in statute. So the board alone could not change that. They had to go to the legislature first. So September 2017, staff starts working with the legislature to get some things changed. In that following, in the following legislative session, the legislature did pass those changes as part of the recodification of the education code. And then the last bullet doesn't matter.
Here.
Oh, thank you. Oh, goodness. Thank goodness. Yay. That's easier. Okay. So we've gone to this point. We've been over a year. We've almost, basically a year and a half, and then the board starts working on rules. So the board passes the first draft of the core rule in May of 2018. But there was a public hearing request, and so the implementation of that rule was delayed. Ultimately, they had the public hearing, they accepted the report, they made a few changes, and in October of 2018, they finally adopted this 301 and 303, the core of this new system. And in December 18, it completed the public comment period and is now considered, it's passed essentially. So it took 2 full years to get to that point. But that was still just the beginning point. There was more work to be done. But there was a couple of things we felt that it's very important that people know as we went through this whole process. And the first one was the board was aware that some of the issues around the APT license was a lack of public feedback. And so the direction to staff was to ensure that we were engaging the field as much as possible in this entire process. We've had, for most of the rules, we've had focus groups, we've had drafts sent out to the public before the board sees them, and then a draft presented to the board. It's been a very rigorous process. The second bullet, though, is also the biggest one. One of the primary issues with the current system is it's not fair. There are different expectations for different individuals depending on your path to licensing. So if you are completing a university program versus the ARL program versus the APT program, which, by the way, doesn't matter if you don't know what those mean, just things, right? They're all different. One has to have a high GPA. One has to just pass a test. One has to take classes. They were inconsistent, and that was one of the perceived problems. So one of the things that the direction to staff was this new system needs to be as consistent as possible. A license is intended to be a demonstration of a minimum set of competency to prevent harm. So however you earn that license doesn't matter. What matters is that everybody gets to the same finish line. So that was really important. And finally, this will make more sense as we get into the next part. But just so you keep in mind, the board's intention of this new system that will have 3 types of licenses is that associate and professional licenses will be the majority of teachers. It is the board's intent that the LEA-specific license is an exception or a temporary solution. That is their intent. If it doesn't turn out that way, the board would likely need to take action. This is not super important. These are all the rules that we have to change for licensing and where we are. It's a lot better than it was a year ago. We've basically got 2 more rules that we have to finalize, and then we're just tweaking stuff. We're almost there. So first of all, before we get into the what, are there any questions about the why, about how we got here? Any questions about that aspect of this? Stunned silence is my favorite silence. Yes.
Just regarding teacher status, not other disciplines, like not speech therapy.
This is all educator licenses, regardless of focus. Good question.
I work with Travis on the focus groups and throughout the year. The evolution of the licenses was drastically different than it is now. I had big concerns about some of the ELA-specific licenses in particular, especially when it came to students with disabilities. So I think most of those changes think they will part to one of the comments you made, you said for a licensing, minimum competency to prevent harm. That's an interesting way to phrase the reason for a license.
So that's my personal definition. That's no one else's legal definition. That's my definition. And I use that definition for any type of license, whether it's a bar license or a doctor's license or a plumber's license or a massage therapist license. The purpose of a license is to prevent public harm. That's my opinion. Doesn't have to be.
I spoke with our school social worker this week, and she said that something just changed for her licensure status as far as our school social workers lost some type of educator licensing that allows them to teach lessons in our classrooms. Does that have anything to do going on?
Yes, though there's some aspects of that we should discuss of what you just mentioned. I'd like to leave that till the end of the presentation, but then we can certainly address that.
Great, thanks.
Okay, so let's get into the what this looks like. What is it? So there are 3 types of licenses in the new system: associate, professional, and LEA specific. The 30-second version of what these things mean is associate means I'm learning how to be a teacher. Professional means I have demonstrated all of the competencies necessary to be a teacher. And finally, LEA specific is I have demonstrated locally established criteria for this license. And that license is only valid in that local authority. So those are the 3 types. Learning to be a teacher, I am a teacher, local requirements.
What are you specifying as local? Local for the state of Utah, or local for a town,
LEA.
or a district? Like, okay, just the specific district or school, depending on where that LEA is.
Correct. Good question. Okay. Yeah.
Is that same structure the structure used for other licenses like school psychologist, speech language pathologist?
Next slide. Okay, so if you're unaware of this, the way that licensing structure in Utah works, there are different levels, if you will. There is a license, there are license areas of concentration, and there are endorsements. So a license, any individual can only have a single license. So for example, myself, I have a level 2 license. Period. Like that's the end of the sentence, right? That's my license. I have 2 license areas of concentration. I have a secondary license area of concentration, and I have an administrative license area of concentration. Those are indications of specific fields or areas in which I'm allowed to practice. And then under those license areas, so for example, my secondary has a math endorsement on it. So I have a math, so I can teach secondary math. My administrative doesn't have any endorsements on it. That's the basic structure of how licensing can work in Utah. And this is actually remaining. And to the question that was just asked, the idea of professional, associate, and LEA specific apply to each of these. That's a little bit tricky to think about first, but I tried to create a visual aid for you. All right. So this is a particular example of what a person's license might look like. So this particular individual has a professional license. They have a professional license area. So like this is me, because I'm secondary. Professional license, secondary professional. And here's my math endorsement. Because my degree is in mathematics, that's my professional level of endorsement. Now, what this represents, this associate endorsement under my professional would mean I'm learning an endorsement. So maybe I want to add a chemistry endorsement or a theater endorsement or some other area that I'm interested in teaching. And so I haven't met all the requirements yet, but I'm working on them. So I'm learning how to be a teacher in that area. And then LEA specific means that my local authority has said, we believe that Travis should teach theater because he was in musicals in college, and they did that. Because their local criteria that they took to their local board that's elected said, Travis can teach theater. Okay, I can teach theater in their LEA. By the way, it was a disaster. Don't do that. I was terrible. It's my second year of teaching. So this would represent someone who's adding a different license area. So if this is secondary, I might be interested in becoming an elementary license teacher. Or I might be interested in earning a school counselor license or a speech language pathology license. I can get these associate license, right? I'm working towards it. And then again, the same branch.
Your LEA specific endorsements, are those going to be approved? Because I can see a lot of flexibility with the criteria.
Hold the thought. Good question. Hold the thought. We'll get there. This is it. Right now, we're just introducing the structure. Now we're going to talk about requirements. All right. So, basically, just the way you structure the rules. Again, to be consistent, every license has a general requirement or set of general requirements, content requirements, and pedagogical requirements. Just in case, if anyone's not aware, pedagogy means how you teach. That's the best way to think of it. So, for an associate license, this is what you need to do. You must have a background check. You must complete an ethics review. You have to have shown academic success. That means you have a degree, you're in a degree program, or you have a specific CTE skill certification in an area that we recognize, such as welding, some of those CTE areas. These licenses are valid for 2 years, with an extension possible of 1 year. So the assumption is this person who's learning how to be a teacher, they have up to 3 years to get to that profession. 3 years max. For content, those requirements are for elementary, they have to pass the elementary content test. For secondary, they have to either pass the appropriate content test or have a degree major in that subject. And then everything else, they have to be enrolled in a university-based preparation program. So, everything else, special ed, school psychologist, SLP, they have to be in a program. There's no other way for them to get that. This is only available for elementary and secondary outside of that kind of realm. Back here and then up here.
Is that new, or is that always been that way for bachelor's?
I don't understand the question.
Is that a new requirement with these changes, or has it always been that way for the other than elementary and secondary?
It depends. So like APT, the academic pathway to teaching that they created, they explicitly excluded special education. ARL does work with special education teachers. So it varies on the program.
And just to be clear, these are their content requirements for the associate.
For the associate. This is what I have to do before I can start learning to be a teacher. Yeah,
Content text, can you give an example of what that is? That's not the praxis, that's
it actually is the praxis. It would be the praxis to content knowledge. knowledge tests in the various areas that we use.
So does this mean that like going forward you could do the like an associate's route to SPED?
Hold that thought.
Okay.
Well, don't hold that thought. It means I can get an associate license in special education. But one of the criteria to receive that license is to be enrolled in a program.
Okay.
So this then replaces kind of what was previously ARM.
Finally, the pedagogy requirements, and again, this is for the associate. They have to complete a series of professional learning modules that are created by the superintendent. They have a series of topics that they have to do. We're in the process of creating these. They are very minimal. These are not 3 credit classes each, okay? This is a weekend of work. 16 hours of work, that's 2. But it's intended as a just, here's the basics so that you don't make a fatal mistake the first day. I mean, one of the things I always like to say is before a teacher walks into a classroom, somebody needs to tell that teacher that IEPs are not optional. Somebody has to tell them that. And so we're trying to get the very basics in these modules before they get this lesson. Now, if you're already enrolled in a university program, you don't need these. We assume this is part of your program, whether it's USU, Weber State, BYU.
And so, with your example of IEPs are not optional, that goes to anybody who's getting an associate, whether it's elementary or secondary.
Correct. These 4 modules, we've been working on the ethics one first. We'll be getting to these others, but yeah, it's intended for anybody who's not in a university.
So somebody studying elementary or secondary ed that is enrolled in a university, are these professional learning modules still required for their associate education license?
If they're enrolled in the program, they don't need them because it would be redundant to our mind. So those are the requirements for associate. That's what we should get. The idea is, when I need to hire that person, I need to get them to a minimum level. Let's get them to the associate, and then we'll work on getting them all of the expertise that they need to be a teacher. So that's associate. For professional. So this is what was really important to the board about making things consistent. Saying, look, we don't care if you're using a university or some other alternative program, but everybody's got to meet the same requirements, and here they are. So the first thing is, you must be recommended by an approved program, university or otherwise. There will be non-university programs. Or you have to already have a license in another jurisdiction. So that's the people moving from out of state that already have a license. You have to have one of those 2 things. These will likely be valid for 5 years with typical renewal. Renewal will be changing somewhat, but that rule hasn't been written yet. So it's one of the last ones we need to do. So you have to do all of those associate requirements. You can't skip anything. You got to have all of those, and then you got to complete the program. For content, for the professional level, they're required to demonstrate all competencies established by the superintendent. So the board is saying the superintendent establishes the competencies for a math endorsement. And everybody has to meet those competencies, whether ARL, APT, doesn't matter. Everybody has to meet those requirements. Right now, those are what we typically think of as the endorsement course loop. If we go to the website, look at endorsement, there's a series of courses. We're trying to move that towards competencies, but that's going to take more time. But ultimately, because a course, this is a bit of a bird walk, I apologize, but a course is just a label. Like when we say you need to take calculus for this endorsement, what we're really saying is that you need to understand differentiation and integrals and the manipulation of algebraic expressions. And calculus is just a label we use for that. So there might be other ways to demonstrate that. And we know, you know as well as I do, calculus in University A and calculus in University B are not the same thing necessarily. There's definitely some similarities, don't get me wrong. But what we're trying to do is instead of having coursework, moving to the specific competencies that the teachers have to have. So that's in the content area.
Can I state superintendent's office?
That's
Or the district itself.
good question. The superintendent in this reference is the state superintendent.
With those move from coursework to competency, what's the timeline on that process?
Really slow.
Or who's involved in that process specifically with those content areas?
We've started the conversations.
Okay.
And the specialists at our office who oversee the various endorsements are starting to have the conversations with their advisory committees, with their field on how they are going to be able to do that. I literally don't think we're going to see them all move to competencies for at least 3 years. But I think we'll start moving faster than that.
So, in the context of this panel, how, throwing it out there, how can we ensure that in all licenses for people that achieve a professional, whether or not at special education related or not, that there's meaningful criteria identified and covered in everybody's competencies to really embrace all this? What are we putting out?
It's an awesome question. They have to be regulated by board-approved program. Part of the rules that we've been writing are those exact things. What are the rules that both universities, LEAs, anybody who wants to be a provider has to meet the criteria in these rules? If you're curious as to them, they're in R277-304. It is a little bit into the weeds. It's not what I'm presenting here. 304. It's actually published already. That one's been passed and finalized.
I guess my bigger complaint, and it's recommended for a board-approved program, but then in your content, you're saying the competencies are established by the superintendent. So those competencies are broken down, and
it's the program's responsibility to ensure those competencies are met. And it's the state board's responsibility to ensure that programs are following that.
right, so you're backing into them proving that competency. So at the top of the requirement, I guess, is your competencies, and then you write down how to get there. So my point is, how do we ensure that those competencies include special education related subjects that can encompass things that are broad-based, like mental health awareness, like positive behavior interventions, like things that the university applied across the board, because the breakdown in special education for our kids is, especially those of us that are passionate about our children in the education setting, is that then teachers do not have equal skills or education or wherewithal to properly support our children in their settings, and whether or not they've got IEPs or 504s for their children that don't necessarily qualify for those that might benefit from them as teachers having this more expansive skill set. So my point is the education parameter really is a significant component in helping our children succeed in their inclusive gen ed environment. So to me, it's kind of critical that our gen ed teachers in any specialty are receiving more meaningful education, subsequently competency expectations. So we're delving into this. So as a panel, being able to help ensure that as this is being developed over the next 3 years, that we are meaningfully and purposefully wrapping that into those expectations. Because we're not going the traditional route where we're only touching on it here and there, or it being an optional thing for gen ed players to participate in if they want to, or if the LEAs want to. It's not succeeding that way. It's not working.
So I think the answer to your question is within 3 or 4. Because when we talk about content competencies, we're not talking about methodology or how you teach or how you work with diverse populations, how you work with special ed. That's not this bucket. This bucket is what content do I need to know. What you're describing is the pedagogy, the how.
I don't do what you do, but I would still disagree because you still have a certain expectation as a knowledge set that you need to achieve. So you get the pedagogy, if I'm saying it right, what you're learning to get to that competency. So like with your special education license, there's certain things that you have to understand before you get that license, right? So with any gen ed teacher, you've got to prove that you've got
we're not bringing it to a competency component, that we're not really ensuring that they're receiving the extensive-ish. We're not confirming that they have that knowledge before they're handed out to the environments to teach.
Okay, so again, that answer is in 304. 304 literally says that a teacher must know how to use multiple systems of supports. They must be able to work with diverse students. They must be able to. All of those aspects of competencies are pedagogy and are in 304. Yeah.
On your next highlight, probably, when you talk about pedagogy, is the same process going to be used to go from course to content?
So, yes and no. Because ultimately, we have this bullet here that says demonstration of all competence established by the superintendent. Really, this is if there's something special that comes up. Right now, we don't envision there being anything beyond the program itself. The program itself is designed to provide them with those pedagogical competencies. So if I'm USU, I probably stick with the coursework model, right? But if I am Davis School District and I'm going to throw my resources into doing my own program, not in special ed, but in other areas, then I can have more freedom about how am I going to demonstrate those competencies. How they do that has to be approved. They have to be an approved program. But they get the choices of, they get the flexibility, if you will, of getting there how they think it's best with it.
So you might choose like coaching side by side with the teacher in order to do pedagogy instead of choosing coursework.
So I hesitate to mention specific examples because it gets into whether or not that truly would mean to me. But the idea of, yes, we think this is the best way to do this. Instead of having a 3-credit class, we're going to have we're going to meet once a week and talk about this, and you have to work with a co-teacher for twice. I'm just making things up, but yeah.
So can I have something maybe a little more specific to along the lines of what everybody's saying? But what my concern is that teachers don't necessarily have any training for like de-escalation or moods of regulation, or how do I help a child and not get after them when they're in their height of this tantrum, and now I'm these power struggles and these things. Like, this is what I'm seeing along the board as far as the teachers and I'm speaking to, and the families and parents. Like, none of the elementary school or junior high teachers that I've have this kind of a requirement or a training set in place that they have to know how to actually deal with students, like to deal with their behavioral and their emotional health in that way. Is that something that potentially is going to be mandated, or is that something that's up to each district or each principal or each administrator to decide what training might teach?
So let's talk about that a little bit. I would say that under the current rules, that kind of thing is already required. If set aside everything, that kind of training is already required. How well it is being delivered, how well it is being received and retained, and how well it's being implemented is a whole different question. I think that it's always professional licensing. One of the things the board is trying to do with this is to separate licensing and employment, right? So licensing gets us to a certain point, but then at that point, there's still continued learning. There's still professional learning. There's still further training, whether it's in specific LEA policies or more generic things that are new. And so licensing is supposed to get us to here, and then from there, it's up to the LEA to train and to...
Is there any way to mandate something like that through the LEA? Because I feel like it may be something that's in place that these students, and I'm coming from a parent perspective, so let me give you my background, that I'm sure teachers are taught these procedures as they're in college, and I was in college, and I have an associate's degree, and I have a bachelor's degree, but in college, I remember learning things and cramming for things, but when you go out to the real world and you're actually, how much of that retention is actually there? And so, yes, these things might be taught in the classroom, but if we're talking about a 20-year-old student that has never seen a special ed student or ever seen a behavioral student or ever doesn't have a brother or sister or niece or nephew that deals with that and then is thrown into a classroom with these behaviors, like how are they being trained to go through that? And maybe
it's a great question, and really, again, maybe for your chair, maybe an exploration of 304 might be a good idea. Because ultimately, what you're describing is the importance of clinical experience, of having work time in a school, of work time with a diverse population, with students with disabilities. when we have a person do what we traditionally think of as student teaching versus an internship, if they're not experiencing those things, then the program is not doing what they need to do. It's always a challenge, obviously, but that recommendation, like you mentioned, we try to cram. This is another piece of that. This is one of the things I wanted to really emphasize here. This pedagogical performance assessment is a new requirement that would be required of anyone receiving a professional license, regardless of how they're getting there. So whether I'm university, ARL, APT, XYZ, whatever, it's just I have to pass this assessment. Now, if you're unfamiliar with performance assessments, these are most similar to portfolio demonstrations of teaching. If you're familiar with the National Board Certification process, these types of assessments are based off that as a model. So you are preparing lessons, you're identifying students with needs, you're identifying your accommodations, you're actually doing the lesson, you're recording it, you're reflecting on it, and then ultimately you're assessed on that. And if you're interested in the vendor versions right now, they are the EdTPA or the PPAT. Those are the two vendors.
And one thing that I think that as a panel we should maybe have attention to is with that, our university is using the PPAT, the PPAT, and they, as a system, it's focused on K-12 education. So for our children with significant needs, they do have special education evaluators, but they don't understand this, they don't necessarily have the scope of evaluators for the environments that our teachers are teaching in. And they don't have early childhood special education evaluators. They lump that in with special education, K-12, and they don't have a system for evaluating children who are receiving instruction that are deaf or hard of hearing, like that are using sign language to communicate. And so those are some things that as we implement this it should be addressed to make sure that our teacher licensing is accessible for individuals.
So are you talking about for candidates taking the assessment or for people?
Yeah.
I mean,
So like our deaf education master students, there's no way for them to engage in the observation part where they video record and submit that part of the task to be evaluated in sign with the PPAT system currently.
So the current, and again, we have to be careful.
Yeah.
So we're talking about the vendor systems, right?
Yeah.
The current vendor systems are required to provide accommodations for any individuals with a disability. That's federal law. And ultimately, those are seen as content agnostic. The assessment itself doesn't look different, whether you're doing 6th grade or 5th grade or 9th grade or earlier. But like you mentioned, it's who's evaluating it. And I think they have different ways of approaching it, the two testing companies that do this. But ultimately, this is not intended to cover, like this isn't like, oh, we don't care about anything else. This is all you have to do. But it's another piece. It's an independent verification of some aspects of preparation.
So first, this is really exciting to me, and I love it. Just how education is moving a lot towards hands-on project-based. This is sort of the adult version of hands-on project-based, and I think that's how a lot of people learn their experience. And maybe this can influence, the pedagogy down the road, and with the LEAs. Because like my husband has taken the alternate route to teaching, and he's the one that all the teachers come to him to ask about special education and stuff because he came up through, he was a para, special needs. So I mean, it's just a real world experience. But what that's done is, even though he doesn't quite have his license yet, he's become the expert there. So I love that this is a chance for people to get in there, have more hands-on, and spend less time just sitting in a classroom per se and really experiencing it. And that's how I think they're going to get these skills, because you can't read a book and then walk in and deal with a child with special needs.
There was a hand over here.
Just a couple of things. So I know that this sparked a lot of conversations about the university programs to make sure that they are more, they're involved in more actual class time. Students are actually out in school more, so more lab hours, those type of things. So I know that that's happening a little bit. And this does replace, but this one replaces the praxis, not the content.
The PLC.
Yeah, the practice. And so this is much more arduous because you have to go through a process where you actually have to demonstrate things like, oh, you actually these combinations that you actually show that. So it's not like when I became a teacher, it was just a test, like it took a few hours.
Multiple choice, right?
Yeah. Wrote one essay, it was like, yeah, I love this comment that started this entire discussion. I looked up 304. It says in the area, just get everyone a little bit confidence. I think it's something they need to look at, but it requires in the general teacher section, it says the teacher has to, it's a requirement to require the demonstration of competency in the following areas. The general ed teacher has to demonstrate competency, and it says, the student, child find, talks about adjusting or behaviors to a child with disabilities, appropriate responses. So there's actually a lot of good stuff in that's required, but it sounds like they may not be requiring that demonstration of competency on the general ed teacher.
If you'd like to jump in there and give us recommendations for changes to that rule, I'd be happy to hear them.
I'm just saying the rule has a lot of there, but we're asking
Well,
for
it
a
sounds
lot
like it's
there.
already in place, but maybe it's not being implemented, and maybe so our
Well,
recommendations.
Because it's a brand new.
Well, none of it, but you're right.
That how to implement it or how to make sure that the checks and balances are in place is what it kind of sounds like. So it sounds like you guys have hit on all those points that we're concerned about, but how do we make sure?
The proof is where the rubber hits the road, right?
Well, and my 2 cents, and Karen, you can correct me if I'm wrong, so we've got 2 hours at the end of our meeting today, that's potentially an area we could get into.
So we're going to be writing recommendations to the state board.
Right, turn it into a recommendation letter that we kind of wrap all of our heads around it and have a good discussion to potentially turn that into a recommendation.
All right, so that's the professional. Remember, those are the pathways that the board sees for the vast majority of teachers. But the board is also aware that there are always unique circumstances. One of the reasons we got to the system we do now is because they started with a basic system and then somebody fell outside of the system, and whether it was the board or the legislature or somebody decided to change the system to try to include them without breaking the system. And then when you do that 20 times, it becomes a conglomeration, just a hodgepodge. It just really becomes a mess. So the LEA specific is seen as the way of allowing for those things. And I can give you examples if you're interested, but it's probably not important. But ultimately, the thing that worries most people when they look at this is there's some very minimal things right here. They do have to request it. The LEA governing board, which is an elected body, has to formally approve the request in a public meeting. The first renewal of any such license must be approved by the state board. So for most people, this is a temporary stopgap until they can get onto the associate to professional path. But there will be some that have to have it here. But content and pedagogy are established by the LEA. Yeah, you'll notice never doesn't say bachelor's degree here. Doesn't say pass the content test here. All it requires is that LEA establish those requirements. Now, if I'm Washington School District and I decide I want everybody to take the test, I can do that, and they're going to put that in their local policy. But ultimately, the state's not dictating that because these are intended to be exceptions. Now, one thing that's important to bear in mind. I want you to think about this. You don't have to respond to me now, but maybe this is part of your conversation. The current board rule at stands says that LEA-specific license cannot be issued in the area of special education. They can't be issued in special education. What I'd like you to think about is how you would feel if we altered that a little. One of the problems that we're running into, because whenever you get into details, things start to bubble up, right? So when someone comes from another state, when someone's finishing up, how do we get them on associate or professional as quickly as possible? One of the things we might recommend that the board consider making that an LEA-specific for special ed can only be valid for 1 year and cannot be renewed. To give it a 1 year window. Now, I'm not saying we're doing that, but right now it specifically, explicitly prohibits it. Cannot happen. So what will happen is we'll have people working in classrooms without a license at all. And if you don't have a license, then if something occurs, the state board can't take action because there's no license to take action.
Can't the state board take action on the LEA?
Yes, they can.
This is the type of that have teachers that are on that alternative track.
So again, this is a little bit, it's not too far, but so part of alternative programs. So all of our programs now are going to be either at universities or districts. Okay? And one of the charges to the superintendent was to create a model program. So one of my staff, some of my staff's job is to create a model program that a district, a charter, or a private school could implement to meet these requirements. And so the rule specifically states that while a private school can't be their own program like maybe Davis wants to be, but they can use the model program we provide.
So with it being valid for 1, 2, or 3 years, can they keep renewing that and having it be?
So ultimately, this is their choice on how long they think they need. Most of them will probably just pick 3. Right? But the first time that comes up for renewal, it has to be approved by the state board. And the intention is that hopefully the state board can then scrutinize that. One of the current problems we have in our system is there are this year going to be like almost 4,000 letters of authorization. Those are kind of temporary emergency licenses, doesn't matter. But ultimately, those can't be scrutinized. If you're a state board member, you can't scrutinize 4,000 requests for emergency protection. So the intention of this system is to put some onus on the local authority, right? Because they answer to their parents. Whether I'm a charter or a district, I answer to the parents. And then ultimately, if they're going to use it for a long term, they're going to renew it, then we scrutinize it. And hopefully that takes the number of scrutiny down low enough that the board can truly scrutinize it. And it's not just 4,000 we get waved through the door, right?
So to answer your question about if they were to open up special
education
lessons. So as a parent, trust is the biggest thing I have in school, right? Especially when it comes to the kid who can't talk. Who can't come home and say, this happened in school today. If we're opening up to people who are not trained to do those things, a violation, even though it didn't happen in my school, affects my trust with the entire school system, right? So, like, whether it be some sort of physical abuse that happened in the student, special needs, or anything else, it affects the trust of the entire parents in the area. And so, because that trust, I think, has to be protected, I recognize the need, because it is better to have somebody who says, okay, we're working towards something, and somebody's just like, because there's just not enough special education teachers. Right? Bottom line is, an adult has to be in a classroom. I could see doing a 2-year certification, but not under the old thing. It would have to be something much more oversight to it than this sort of, like that. My biggest concern about the license structure, we've talked about several times, the LA specific part. Just that it was so open. It becomes a special ed, I wouldn't want it this way. I want to say that you have to be able to track these things. Like there has to be some very minimal things that you do. So just to protect that trust. But I'm not opposed to the idea of getting somebody in the classroom, it's important.
So in the interest of time, I think this will be another topic that you guys might want to discuss. We'll leave it for you to discuss it. And whether you want to send individual feedback or you'd like to send feedback as a group, either way is fine. Okay. We're going to go in the back and then we'll come up here.
I agree. Yeah, I find myself in this odd situation. Odd to me because I never thought it would happen. After almost 39 years, all of a sudden, all of my 17 kids are either out of the house or in school. Unfortunately, I am at the high school to take care because we can't pay a nurse. But I found myself 2 nights ago in the IEP for my son, with colleagues, because I am part of the team that have been for 3 years.
saying, okay, my kids are in school, and as soon as we find a nurse, which one of your professions should I join? Because I'm passionate about speech. I'm passionate about SPED teaching. I'm passionate about PTOT. I have 17 kids. 9 are home, and all are disabled, and all I do is SPED. So I disagreed because I don't have a degree. Because I left my almost done associate's degree 40 years ago and have been parenting SPED ever since. Would I be an asset to the classroom? Well, I am right now. I'm getting paid to be a take care person and live with the nurse. You better believe I'm doing SPED all day long. So I don't know how we make a little bubble for the, 0.1 percentile of us parents who know this more than anyone else. But I think there needs to be.
So what's the current process though? So if they don't do LEA specific, they have an opening in a special education classroom and they don't have a licensed, somebody who currently has an associate license. In the past, they would hire a letter of authorization. They would have a short period of time to be enrolled in a program. So what is the process with this license?
What it would look like would be, if this is not a, if this remains as it currently is, they would simply be hiring a non-licensed teacher. And they would be out of compliance with having a licensed teacher until they have an associate license.
So we just require the district to push them quickly into that associate license.
Well, and we can.
Or hire
So if we want to talk about what the real consequences are for having, for not having a licensed teacher, they're pretty minimal if you didn't know that already. But let's move on. Let's move on. Okay. So transition. Now this is again maybe not necessarily for all of you, but ultimately. Level 1, 2, and 3 license holders, if I have a standard level 1, level 2, level 3 license, when the system flips, I will have a professional license. It will just swap right over. Okay. For PLT for level 1s, this has been some confusion. There's been some relaxing of the I requirement for the PLT because of this transition. But one of the things that people have been confused about, and if any of your teachers know anybody on an APT license, please make sure you tell them this. Yes, the board removed the PLT requirements for standard level 1s to move to a level 2. For that APT to get to a level 2 or a professional in the new system, they still need the PLT. That's part of their program. And if they have any questions about that, call me. I can help them. But ultimately, what's happening is, so they'll just switch to professional. Our alternative people will basically be moved to associate. And then they will have the choice. They can either choose to complete their already established program. So APT can do what they were already doing. ARL can do what they were already doing. Or they can switch to the new requirements, whatever makes most sense in their circumstances. If I only have one class left, I probably just want to take that class. If I haven't taken any classes yet, maybe switching to the new system might make sense for me. Who knows? But we want to give them that. Current SAEPs. So if someone is on what's called a state-approved endorsement plan, that's someone learning a different endorsement, basically those will just switch to associate. And then basically everything else, including LEA-specific in the current system, basically ceases to exist. Those licenses expire, they go away. So for LEA-specific licenses under the old system versus the new system are two different things. But if you know your charter, your school is using those kind of licenses, they should be aware that those things are kind of changing. Yeah.
Question. So if a teacher is on an LEA specific license, does the school have a requirement on other licenses?
Good question. Okay. I didn't put this on this slide, but if a district or charter school is employing teachers with an LEA specific license, they are required to post on their website the aggregate percent of teachers on the various licenses. So they don't have to identify individual people. They don't have to say this person is this is this. Though technically, if the parent went to our website and looked, they'd see, right? But what they're required to put on their website is their percentage. So if you see 10% LEA specific or 20% or 90%, they have to publish them as part of it.
Wait, on their website?
On their website. I think it says prominently, but I can't remember. It's in 301. Okay. I always like to end this position or this presentation with this again. This is the point. This is what we're trying to accomplish. And if we find flaws in this system, because we will, let's be honest, there's no such thing as the perfect system. We need to address them because this is what we're trying to accomplish. So when you see issues, when you see problems, we can go for them. Now, I think we need to bring up one more thing because I think it's especially relevant to this group. It's not in this presentation. And that is the school social worker issue. And that was addressed earlier. So right now, rule, and you don't care about the number, 306, that governs the preparation of support service areas, SLP, audiology, school psychology, school counselor, all of it, is currently up for review. Our proposed revisions have gone to the board. And there's been a public hearing requested to get more public impact or input on that. What's going on is, yes, what was described earlier, the new rule is essentially removes mention of a school social worker license. The intent being that there would not be school social worker programs in the future, so that license is phased out. Now, again, some of the rumors that have been going around that keep getting in my inbox, we're not taking away anyone's license. You have a school social worker license, you will still have it. And you will still be able to practice in a school. That is not changing. But what will happen is we will discontinue issuing new ones. So there will be a point where we kind of do the last ones and the license phases out. Similar to, if you didn't know this, Utah used to have a middle education license area. It was middle, 5 through 9. There's still a couple of them hanging around. But it phases out over time.
Why?
Next question is why. So here's the issue. The practice of social work and school social work is very difficult to distinguish. And one of the things that we've run into, because what we were doing in this rule, we were trying to look for, national standards or standards in the field to say, okay, how do you prepare a school counselor? How do you prepare a speech language pathologist? And when you look at social workers, there is an organization for social workers, and there is an organization for school social workers. If you go to their websites and look for how you prepare those people, they point to the same third-party organization. There is no distinction in the preparation of those two. So if there is no distinction, then we are basically duplicating effort between our office and DOPL. So the intention was, now there's some good arguments on the other side. I'm not presenting the other side. There are some good ones about, the role of a school social worker, what it means to be. But ultimately, the question is not whether school social workers are valuable. That is not the question. The question is whether or not there should be a state license dictating who can practice in the field. Okay, so you've got some districts that have very fleshed out school social worker programs that are very meaningful. But ultimately, is that really something that we need to enforce on the state, or is it something that is just what they need to do on their own? So that's the open question. They're going to have a public hearing on it. It's currently being scheduled. So that question is still open. Hopefully that clarifies. Yeah.
Let me just speak from a social worker's perspective. Sure. So I work for DCFS, and I'm currently in my master's degree, so I will be in LCSW, because of that requirement that you have school social work certification, endorsement, whatever you want to call it, I'm not able to hop over into the school social work arena, even though I think that I'm uniquely qualified for that because I've been in child welfare for so long. So I see this as essentially opening up the pool to more people who would be qualified, similar to what she was talking about back there for parents, so that some of us who have other unique expertise, areas of expertise that might be helpful in school will be able to do school social work, right? And our curriculum, the curriculum for a master's degree in social work, like he's saying, it has the same basis and principles that.
The only distinction currently is a clinical experience of 300 hours in a school. That is the only distinction.
And don't a lot of social workers do some of their internships in schools too?
Yes.
Or parts of it?
But for someone like me, like I'm in the child welfare track right now, and because I'm working full time on top of doing the practicum, it's impossible for me to do a practicum in a school. But does that make me unqualified to do school social work in the future? I don't think so.
One of the things to bear in mind is there are unintended consequences. There are specific legislative funding sources tied to educator licenses. So the board is being very cautious about this. They know it's sensitive. We're going to have the public hearing. We're going to get some more feedback, and then ultimately the board will decide what they want to do. But any feedback you have on that, you're welcome to send to me as well. And I'm still part of that.
How does school social worker position differ from the speech and psychologists, because they too have programs and they have time that they have to spend in service?
So I can answer the school psychologist and answer quicker.
Okay.
The distinguishment, the requirements to be a psychologist with DOPL and the requirements to be a school psychologist are different. They're a different set of standards. SLPs, I can't give you as good of an answer because they are kind of in a similar situation. But then we get into the vein of, and if you've ever spoken with Joel Coleman about this, he's been talking about this for years now. But what about occupational therapists?
Yeah.
Physical therapists, orientation and mobility specialists? Where do we draw the line? So right now it seems like the board is comfortable with keeping SLP, but letting school social work go. But I can't give you a great.
Speaking of speech language pathologists and school psychologists, do they follow that same associate and professional? So at what point, what would an associate in that field be? Somebody who's enrolled in a prep program, and would they have to go through the same performance-based demonstration?
So the rule specifically says the performance-based are available, and right now it's only available to my knowledge in instructional areas.
Okay.
So for school social workers at SLP, it would unlikely be required in those areas.
Is there a secondary thing that you substitute for that, or they just don't have to meet that requirement?
Well, that's why it says all competencies established by the superintendent. So that means I could throw something in there. Not really, but that was a joke. Not that I'm aware of, but that doesn't mean it's not part of the discussion. I mean, I know like SLPs are tied very closely to ASHA. So getting your ASHA Cs is like the expectation, whether or not it's actually in the rule or not. I don't know.
Does it start January?
So, okay, there's a lot of confusion about this. It actually starts next school year, okay? When you read the rules, you're going to see it say that they go into effect January 1, 2020. That scares everybody. That's not what it means. January 1 is when the rule goes into effect, so ultimately our staff then has legal authority to start making changes. So from January 1 to June 30th, actually both sets of rules will be valid, quote unquote. And so we'll be transitioning, and then July 1st is when the switch flips, if you will.
I just wanted to say thank you. Well, thank you for your presentation, and as a parent and a wife of a husband who's working towards getting his license, this is exciting to me because I think as a parent too, it's not necessarily what class you took or this or that, but it's the effective educator approach. And I love how you create space for everyone and emphasize the practicing of it. And thank you for all the work on this. I think it's great.
You're very welcome. And I'll be sure to pass that along to all the other people to help, not just me. This is it.
Yeah. You must consider putting back in special ed.
Yes.
You devil's advocate for a second, or I'm not informed. What are the best arguments to continue to have that exclusion? This is why we're evaluating to make sure we hit all the bases.
Okay, so the best arguments to exclude the parent trust is a big issue. So a licensing system is only as valid as people believe it to be. Like, if I didn't think, I'm not going to get into that. But so if parents see LEA specific as meaningless or no requirements or whatever it could be interpreted as, and they see special ed teacher and they see that special ed teacher on their website and they realize that person has an LEA specific, it can undermine that trust and create a problem. For example, there was you may or may not know about this, but this was last fall. There was some parents that came and made public comment to the state board about the fact that their special ed teacher was an ARL. And so just that label created the issue. So when the board says no, it's about sending a message. It's about saying to your district, look, you better have some safeguards and you better get into associate as soon as possible if we keep that excluded. And I think that's probably the most important messaging and vision of what it is.
It is a higher target risk environment in the sense of lawsuits.
Yes, it is. Yes, it is. Absolutely.
Since you understand both the official rules and some of the kind of back channels and how it actually works, would the effect of allowing 1 year LEA-specific special ed licenses drive these people to actual programs more strongly or less strongly than what we have now?
I think if there's an exception to the rule, there's more possibility for it slipping through the cracks. So one of the things that this gets into some details that some of you may not care about, but like if we're in our current system, a person coming from out of state, sometimes it takes time to get your license transferred, right? And so often what will happen is a district or a charter school will put an out-of-state person on a letter of authorization to give them time to get their license, right? But I cannot tell you how many times I've gotten a phone call from an HR saying, this person's been here for 3 years and they keep telling me they're submitting their application. And I go, look, and they've never sent us thing one other than the background check. And so those things, those kind of slip through the cracks. They happen, despite our best efforts. And so that's what would concern.
My question is, so you've got, aside from the proposed 1 year LEA-specific license, you have the associate license and the professional license. So in typical degree realm, associate takes 2 years, and then a professional master's takes a lot longer. So how does a 1 year allowance on a LEA specific correlate to a associate's that's 2 years?
So because all I have to do to get an associate special ed is have my degree or be enrolled in a program and do those modules.
Being enrolled in an associate.
So they have to be formally admitted. So it gives them, so that year gives them time to be admitted into the program and for the associate license.
And just, you might be confusing associate's degree with associate.
Yes, yes. Sorry.
So, under the new license structure, is there more sort of sideways mobility for teachers, in particular, like a regular teacher who wants to become a special education teacher, they would do the associate license while they would have that same freedom?
Yes, the intention is that the modeling preparation program that we're going to create will still have those pathways. Like, for example, the performance assessment. If you've passed the performance assessment and have that professional license area, you don't have to take it again. So if you have that professional instructional area, elementary, secondary, special ed, and you want to switch to another one, you don't need to take that assessment again. You still need to meet the requirements, whether I go through Weber State Prime or SU or whatever. I still have to meet the requirements, but I don't have to redo that assessment.
But those competencies maybe wouldn't be tied to course load. It'd be like, I have experience in special ed stuff. I want to transition. I just need to show that.
It's like what we do in ARL now. When someone comes to ARL and already has a license, and we're like, oh, you don't need intro to special ed. You have a license. You're a licensed teacher, right? So I'm going to go in the background.
How does this, and you did the thing, but how does this framework compare to the rest of us? I just want to know, like,
Leading edge. It is. It's a lot of states have been watching us over the past 3 years. They're looking at it because, again, the very valuable things here are the consistency, the simplicity, and the disconnection of employment from licensing. Because for a long time, we've had this connection of mentoring and upgrading and, whether your career status or provisional status and employment, and all these licensing and employment issues got mixed together in a bag, and it was a legal nightmare a lot of times. And so really that idea of separating those two as completely as possible is really viewed as an ideal, if you will. Not by the entire field, but for people like in my position, they like that kind of cut and dry, this is my responsibility here. But I'm not aware of anyone else even pretending to go in this direction yet, so you were next.
I had a question, but I was wondering if we wanted to maybe break for our lunch and then ask.
Can I ask a question? So say someone is an LEA exception or whatever, the responsibility to make sure that they don't slip through the cracks or that they do that is on the LEA, right? That is not the state to be policing that.
Which is just like that example I mentioned. It was the district's responsibility to still provide FAPE, right? And they still had the responsibility to provide that teacher with the tools they needed to be able to provide FAPE. And if they don't, it's the district to sue, right? So.
I'm just going to ask the consequences that you see if they're not in line with licensing. You briefly mentioned.
Oh.
Is there disciplinary action that is taken? Is there a fine? What happens if the school district or a charter school?
So. This is the dirty little secret. So if a particular educator is not licensed, the LEA misses out on about $8,000. That's it. Now, technically, the rule allows if the LEA has a pattern of doing it, that the board can withhold more funds. They've never done that.
But the special ed.
But special ed is different. Yes. Sorry.
So that's Travis's rules,
Yes.
right? The board has a separate rule, R277-7500, okay, that requires that for special ed that the providers are properly licensed, and it is responsibility of the LEA. But we can withhold special education funds, federal and state, actually, according to another rule, R277-114. If the LEA is not in compliance, and obviously anyone could file a dispute resolution, could file a complaint, or a parent could file a due process hearing, and they would win.
Yes, they would win. They would
Because the
win.
rule requires that the special ed teacher or the provider, the speech language pathologist, the school psychologist, is licensed.
So has the state ever withheld funds for that reason?
No, we have withheld funds. We have not ever withheld funds for that reason.
Have you ever seen that come up, though?
It has come up. It has come up in complaint investigations. Even last year, we had a complaint investigation related to licensure. It had. In my tenure, I don't think it's come up in due process. But like Nate told you, we haven't had a due process hearing of like 4, maybe 5 in my whole 11 years at the state board. But it has come up in complaint investigations. However, you do have to remember that special ed rule allows a non-special educator to provide services if that individual is properly trained and supervised, and if the LEA can demonstrate documentation. So if the services are being provided by a paraprofessional, by a general educator, and the LEA can demonstrate training and supervision, they meet the rule.
Will that stay the same in this?
Yes.
This year?
Yeah, this shouldn't change that.
So that's how Alpine District has non-speech passports. So they've been trained and
if they're SLTs, no, they're actually licensed. But if they're aides,
working one-on-one with the but you get paid it.
I think it's probably time for me to turn this over to you.
Okay.
Thanks, Travis.
Yeah, so at 12:30, I think that's when okay, so but who went out the community organization thing. Okay, so we will thank you, Travis. So be thinking about your questions and your suggestions, and we will get to those later this afternoon. We're going to have a lunch right now at 11:45 to 12:30, and then at 11:45 we will do the UC business, and then we'll move on with the agenda. So, do you want to tell us about the dinner, the lunch?
Yeah, so it's potatoes. It looks like it's a potato bar. So,
Also, I found that R27730 and emailed it to everyone if you haven't seen that and you want to look at it during lunch.
It's too bad.
Sit down.
It's really good that she does. We will be there, but sometimes that's a lot of cheese. Oh, it's a salad. I didn't know this is a salad. I thought it was chicken. I was doing it
So I was saying,